We live in a Web 2.0 world, basically a world of Facebook, Twitter, YouTube, Pinterest, where just about anybody can turn themselves into a one-person broadcast medium. Unfortunately, this has not been so good for the law, and especially for jury trials, an area where information is supposed to be kept under lock and key, and something like a jury is only supposed to consider the information that's presented in court. Now, nowhere is this more apparent than a case in California where we might have a jury verdict get thrown out where 5 men were accused in a brutal gang beating because the jury foreman posted some information about the trial on his Facebook account. Now, to me, the Facebook post can't get any more innocuous than what the foreman posted. The foreman basically posted, "Back to jury duty. Can it get any more boring than going over piles and piles of phone records?" This one Facebook post has gone through 2 years now of major hassle, whereby basically another juror who friended the jury foreman informed the defense counsel that the juror AR, he was the jury foreman, was making posts about the trial on his Facebook account. So that led to discovery. Basically, AR wouldn't turn the information over, so the defense counsel had to subpoena Facebook, who would not turn the information over under the Stored Communication Act. However, Facebook said that AR could willfully give up the post, which of course he never would and hasn't. But through the beauty of cyberspace, people took screenshots of his information, so you know that it's out there. But again, this can't be used in the court of law unless it's subpoenaed through Facebook or the juror turns it over. So right now, as it stands, the lead defense counsel is trying to get this information brought in so that the verdict on these 5 men could be thrown out. Now, the reason this comes into play is because under the Sixth Amendment, defendants have the right to a fair and impartial jury. And the more and more that a jury foreman or a juror is posting information about a trial on Facebook, the less this juror starts to look impartial and like it's a fair proceeding. However, the defendant's Sixth Amendment rights must be weighed against the juror's First Amendment free speech rights, because in America we do have the right to free speech as long as it's under a governmental entity and not under a private entity like your employer. You do have certain rights of free speech. So while the juror does have a right to free speech, there's also certain details he cannot reveal against the trial. So this is the main tension here. This case just went to oral arguments just a few weeks ago. At the time of this video blog, it's early April. So hopefully by the end of this month, we'll know the court's decision. Now, instead of one innocuous Facebook post, imagine that the defendant had put on his Facebook post that he'd done a lot of outside research on Google. He had looked up this information and friended the defendant even on Facebook. Then that starts to get to the point where you're starting to think, yeah, this is definitely not a fair and impartial juror. However, with just one Facebook post commenting about how boring the evidence is, I don't see where any court would overturn a verdict due to that one Facebook post. My name is Jason Castillo, the Director of Legal Education with Attorney Credits. I just wanted to bring this video blog to your attention. You can go to our Attorney Credits legal blog for more information on the subject. Thank you.